According to an article published on Monday by the Finance Feeds, XRP whale and rival Jed McCaleb is probably praying that Ripple wins. Jed McCaleb, the co-founder and former chief technology officer of Ripple, left under some unfriendly circumstances to start out his own crypto company, Stellar XLM, and he's been selling off huge amounts of XRP tokens despite the SEC lawsuit. A move that's been considered by members of the XRP army as a deliberate effort to dump on the value of the digital asset. In other news, Bitcoin tops the $39,000 price margin for the first time in 6 weeks, following speculations that the e-commerce giant Amazon would soon accept the cryptocurrency as a means of payment. This speculation arises from the recent job post publicized by the American multinational tech company for a digital currency and blockchain product lead. The said advert hinted the role would be based around the tech company's payment acceptance and experience team, a direct indication that the company is likely to accept cryptocurrencies sometime in the future. Welcome back to Make Money Online. If you haven't already, consider hitting that subscribe button and turning on post notifications. We also have a free Discord group where we share daily signals, and now you can also support us on Patreon. We have a special offer for our first 100 members, only $9.99 for our VIP Discord channels, where we share much more in-depth analysis and even one-on-one sessions. We also have a special discount offer on Binance. You'll get 5% off every trade you make on the platform if you sign up with our promo link in the description. Also in the description are links to get your hands on GSX, the gold-backed currency. This growth coin is designed to withstand market volatility, and it's backed by real gold and other mineral resources. Be sure to check out the links in the video description. Following the trend of events that ensued as a result of the lawsuit between Ripple and the SEC, a few attorneys have risen to prominence, which include lawyers like John Deaton, James Filan, and Jeremy Hogan, all of whom encompass the XRP community's favorite trio at the moment. In a recent YouTube crowdsourced interview hosted by Jeremy Hogan, during which the celebrity lawyer had gained a fair amount of popularity through his YouTube channel, had answered questions relating to the latest updates on the ongoing lawsuit, in addition to the current standing of the erstwhile Ripple employee, given the present litigation. Jeremy Hogan, who's dedicated his YouTube channel to fill us in on all of the latest happenings in the Ripple vs. SEC lawsuit, further adds that, contrary to popular belief, Jed McCaleb is quite bullish about XRP winning the case. The 7-month legal battle between the United States financial watchdog and the San Francisco-based fintech firm shows no sign of an imminent end. The court is seen to be observing due diligence before it finally dismisses the SEC's claims. All indications point to the fact that the SEC has filed this lawsuit from a biased point of view rather than a concrete one. Judge Annalisa Torres has gone on ahead to extend the proceedings by another 60 days, following the plaintiff's request for an extension of the discovery date. However, we're seeing a bit of a turnaround in this lawsuit, as we got 2 of the SEC's commissioners, Hester Peirce and Elad Roisman, both of whom are also lawyers themselves, going on to write that there is a decided lack of clarity for market participants around the application of the securities laws to digital assets and their trading, as is evidenced by the requests each of us receives for clarity and the consistent outreach to the commission staff for no action and other relief. Following these statements by Hester Peirce and Elad Roisman, the Ripple Council had gone ahead to issue a case to the court on Monday, July 19th, via ECF directed to Judge Torres, citing the case of the SEC's settled action with Blotix Limited, formerly known as Coin Schedule, for violating Section 17B of the Securities Act, which reads, "We write on behalf of defendants Bradley Garlinghouse and Christian A. Larson in the above-captioned litigation to inform the court of supplemental authority that supports the individual defendants' pending motions to dismiss the first amended complaint, ECF numbers 105 and 110, attached as Exhibit 1 is a public statement dated July 14th, 2021 by SEC Commissioners Hester M. Peirce and Elad L. Roisman in connection with the SEC's settled action with Blotix Limited, formerly known as Coin Schedule Limited, for violating Section 17B of the Securities Act. The public statement further supports the individual defendant's motion to dismiss for failure to adequately plead that they allegedly aided and abetted Ripple's offers or sales of unregistered securities." In yet another court document from a day after, the defendants further urged the court to consider statements made by 2 of the agency's commissioners, statements of which the Ripple lawyers had indicated entailing supplemental authority in support of Ripple's opposition to the SEC's pending motion to strike Ripple's fair notice defense. Nonetheless, the SEC had responded with a statement suggesting 5 key reasons that they think would dispose of the defendant's motion. On that note, the SEC went on to point that defendants' arguments are tantamount to arguing that they cannot be found liable for violating a statute on the grounds of certain public statements by legislators who disagree with the statute. The individual defendants in this case, which include the CEO of the blockchain startup Brad Garlinghouse, as well as the executive chairman of the company's board of directors, Chris Larson, who have now filed their specific responses, both of which deem the SEC's reply as one that's going on to rebuke these two commissioners' considered views publicly, that the commission does not have a clear-cut regulatory framework. The new developments in the lawsuit were first brought to the community's attention by none other than attorney James Filan. According to these posts by James Filan, the SEC maintains that these statements from its commissioners are not to be considered a statement of the commission or any binding authority on the court. Following the individual defendant's subsequent letter based on this statement by these commissioners, James Filan tweeted, "Individual defendants respond to SEC's letter regarding the public statement by Commissioners Pierce and Roisman, describing SEC's response as going on to publicly rebuke these two commissioners' considered views that there is no clarity." The defendants also added that the SEC failed to prove or support its aiding and abetting charges. According to the counsel representing the two top executives of Ripple Labs, and despite the SEC's assertions, there is a decided lack of clarity for market participants around the application of the securities laws to digital assets and their trading, and that the SEC, through its response to the recent statements made by its commissioners, both of whom are collectively specialized in general corporate law, market structure, corporate governance, M&A, securities, derivatives, contracts, and financial market regulation, is gratuitously attempting to argue its meritless, flawed, and ill-conceived position before initiating this lawsuit, under the tenure of John Clayton as the SEC chair back in December, during which time the commission had levied claims under the circumstances that the defendants knew or were reckless in not concluding that XRP was security as long as 8 years ago. The defendants' lawyers also counteracted the SEC's motion, contending that the charges against the individual defendants should be decided based on the Howey test, a test that no longer suffices in this new and digitized economy, as was seen in the cases involving Kik, Telegram, and NAC Foundation, as indicated by the commission in its letter. Ergo, according to the defendants, the Kik and Telegram cases did not involve any claims against individual defendants, and the NAC Foundation case did not involve claims of aiding and abetting under Section 15 of the Securities Act. James K. Filan, about a week ago, quotes a statement from Ripple that says, "We've reached an understanding reflecting a compromise by all parties, pursuant to which the defendants may examine Mr. Hinman on various issues without triggering a privilege objection from the SEC. At this juncture, if there's just about one thing that we could all agree upon, the SEC has a lousy press and zero amount of trust. Whether this agreement is based on reaching an amicable settlement before the actual deposition of the former SEC employee, William Hinman, is still a bit sketchy. But that won't stop the growth of Ripple nor its native asset XRP. Speaking of coins, have you ever heard of the GSX coin? It's your best bet in these gloomy markets. Developed by the Apollo fintech company, the platform is currently hosting a competition to reward its loyal investors, at the same time offering its investors the option to sign up for as low as $50 to reserve a single ticket, which allows them the opportunity of winning a grand prize of a supercar and $1 million in gold in GSX. You can sign up by visiting the company's official website at www.gsxcurrency.com. Links to that are in the description section below, so be sure to check them out. And we'll see you next time.